Hello, thank you for joining me again in another video where I inform you of labor related matters. Today I want to talk about condonation. I made reference to condonation on previous videos where I spoke about referring your case to the CCMA and also where I spoke of jurisdiction. Now, if your referral is late, and preferably know or calculate for yourself whether your referral is late and how much, with how many days is it late. Now, if you know from the onset that your referral is late, it is preferable that you also fill in or complete the condonation application. You'll find it from the website and from the CCMA offices or bargaining council offices. Now, if you first refer your case to the CCMA, look out for the condonation application for conciliation. Okay, to refer your case for dispute for conciliation. Now, with the condonation application, this is a jurisdictional matter because if your referral is found to be excessive in the degree of lateness or the reasons that you have provided are not sufficient, then it might not be granted and you would not have another platform to refer your case to the CCMA or the bargaining council. Now, if you look at the condonation application, it will have few factors or questions that you have to answer. Okay. First of all, it requires you to indicate how late your referral is. Look out for the video where I explain how you calculate the days. With the dismissal case, you've got 30 days to refer your case to the CCMA or to the bargaining council. With the unfair labor practice, you've got 90 days. And with unfair discrimination cases, then you've got 6 months to do so. Okay. Now, the first issue that or the factor or the question that you have to answer, it is the degree of lateness. How late is your referral? You have to indicate how late your referral is. But be mindful that the commissioners will also make their own calculations based on the date of the dismissal or the date of the date the dispute arose. Then they'll make their own calculations. Sometimes people will write fewer days, but when we do our calculations, we find that it is more than that. So you have to indicate that. Then the next question would be the reasons for lateness. You have to indicate what you have done that led to you to refer your matter late. And you have to indicate all the factors or the reasons why your referral was late. Be mindful that this condonation application, the other party, the employer, is going to oppose it or may oppose it. And if you do not put sufficient information with that opposing statements from the employer, your application might not be granted. Okay, so provide sufficient information as to why your referral was late. If you went to the Department of Labor or you sought advice from your legal rep or whatever it is, put those dates as to what happened. Or if you were ill, indicate that, and if necessary, provide the documentary evidence with that application. Because if you do that, then you are likely to persuade the commissioner or the panelists to grant you that condonation. Okay. The next question will be the prospects of success. This is where you have to provide the merits of your case as to why you believe that your matter would succeed in that forum. You were unfairly dismissed, for instance, the employer did not follow the procedure, or just to indicate the prospects of success that you have. So you have to go a little bit deeper and show the defects, if there are any, on the part of the employer and why you believe that the commission or the bargaining council has to grant you the condonation application. Because if you just write one sentence, whereas when it comes to conciliation, you've got so much to say, remember, if the employer opposes that, unfortunately, you might not have a second chance to do so. Okay. The other question would be the prejudice. This relates to in an instance where the commission or the bargaining council refuse your application, how would it affect you? You have to indicate, probably you don't have another avenue to refer your matter and so forth. But you have to answer as to what will happen should the commission or the bargaining council not grant you this condonation. How is it going to affect you? And you have to indicate that. Okay? And there is also a portion where you have to complete general information. You might not have had an opportunity to include everything under those subtopics. Then in general, you have to bring anything to the attention of the commissioner or the panelist as to try to persuade them to grant you that condonation application. And as I said, if there is any documentary evidence, proof that you want to submit, whether you were ill or you were arrested, whatever it is, submit those. And after it has been presented before the commissioner or there is a hearing for that condonation application, then the decision will be made. But what I have seen is that a lot of people take it for granted that the condonation would be granted, and they do not provide sufficient information as to why their referral was late. That would also be the case with you referring the matter for arbitration after 90 days has lapsed from conciliation to arbitration. You have to indicate as to why your application has been delayed. Okay, so I hope this helps you, and next time when you have to complete a condonation application, you would know that you have to provide sufficient evidence and that the employer may object to your application. So hopefully this assists you. Thank you for joining me. Bye-bye.